Hello friends, in the series on the income tax cases, today we will discuss a very important issue that every assessment year is a different assessment year. Whenever the assessment proceedings are going on for the every assessment year, the assessee has to prove for claiming the expenses that there is actually the rendition of the services, and the importance of evidence is year wise. If some relief has been given to the assessee in 1 year, then only on the basis of that relief, the assessee cannot seek the relief in the different assessment years without fulfilling the specific requirement of giving the evidences for the rendition of the services. This issue has been taken up by the Honorable Delhi High Court in the case of Akzo Nobel India Private Limited versus Additional Commissioner of Income Tax, which has been reported in 460 ITR at page number 477. The matter has been decided on 27th September 2022. In the present case, some transfer pricing adjustment was done in the case of the assessee, which has been upheld by the tribunal, because according to the tribunal, the assessee is not able to provide the evidences for availing the administrative services from the associated enterprises. When the tribunal passed the order against the assessee preferred the appeal before the Delhi High Court by saying that the tribunal had erred in adopting comparable uncontrolled price method without demonstrating any comparable instances. When Delhi High Court heard the matter, Delhi High Court was of the opinion that during the appeal before the tribunal has asked a very specific query to the assessee that whether the assessee has provided the evidences for the rendition of the services. The assessee has failed to give the evidences at the time of the assessment. The court said that every assessment year is a separate assessment year, and in the present case, there is no substantial question of law because the assessee has miserably failed in providing the evidences. The court said that when there is a difference of opinion regarding the appropriateness of method without demonstrating that the method which has been adopted by the assessing officer is contrary to the income tax rules 10b and 10c, then the appeal before the High Court will not lie. Meaning thereby that in the present case, when the assessee is not able to provide the evidences before the lower authorities, that is the income tax officer, CIT appeal, the tribunal, the assessee cannot say that my matter should be remanded back, I will provide the evidences, because the assessee has been given 3 chances to provide the evidences and the assessee was not able to provide the evidences before the various forums which can prove that the assessee has received the services from the associated enterprises. Simply because the assessee's version that in the subsequent years the assessee has provided the evidences and the submissions of the assessee has been accepted and no additions have been made in different assessment years, so same plea cannot be taken by the assessee in the another assessment year without fulfilling the requirement of submitting the evidences. So friends, in the assessment proceedings, the assessee has to keep in mind that when the assessment is going on, the assessee should try to provide the maximum documents, the maximum submissions, because if the assessee fails in fulfilling that requirement, so the path of the assessee becomes difficult when the assessee moves upwards, because if the assessee will submit the documents at the time of the CIT appeal, then the assessee has to make the application for that, and then the CIT appeal will take a remand report from the assessing officer, so it only lengthens the whole litigation process and the case of the assessee becomes weak. So in the present case, Delhi High Court dismissed the appeal of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Akzo, Nobel India Private Limited versus Additional Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 477. The matter has been decided by Delhi High Court, and the date of the judgment is 27th September 2022.